Hello, welcome everyone. My name's Rilus Dana, and it's another free webinar Friday. Have an exciting topic today. So today I want to discuss how to take title for real estate. So this is if you're buying a house or buying a property, the title company will ask you how you want to take title. So today I want to go over some information about some options for taking title, and I want to show you a way where you can take title to property and keep your information private, a way to keep all the information of the owner off the public record. So some pretty cool stuff. Let me share my screen here with you. If you have any comments or questions, go ahead and leave them in. Leave them in the comments. We'll try to get to them. If we don't get to them live today, we'll try to circle back and answer them next week on our next live stream. Okay. So this is my contact information. This is where in Arizona and Southern California. Also the founder of Mott Legal provides our software for our estate planning documents. This privacy, it's one of the newest offers from Mott Legal, so it's included in the Mott Legal software. Okay, so real property title options. So we've got a house here. Here's our good friend, Mr. Estate. Now, if he's single, the way he takes title to the house is pretty simple. It's going to be just in his name. Where it starts to get a little bit more complicated if he's married. So if Mr. Estate's married, we need to clarify if this is his sole and separate property, if it's just in his name, or if it's owned together. So when property is being transferred to someone who's married, if it's an inheritance, there's an option to receive that as your sole and separate property. If this was a property that Mr. Estate purchased while he was married, it would be their community property. So he wouldn't be able to take title in just his name as his separate property. Even if he did, even if he set up title that way as a married man, as a sole and separate property, if the monies from this house, if it came from their community property, their combined assets, or even if it came from his paycheck to purchase this house, it would be considered community property. Not going to get into community property today. That's a good subject for another day. We can talk more about community and separate property. But today I want to go over the title options. So if there's multiple owners of a property, there's going to be more than one owner. That's with more options. Now, by default, whenever there's multiple owners of a property, it's going to be tenants in common. Whether it says this on the deed or not, there's a presumption that it's tenants in common unless it clearly says otherwise. So with multiple owners, with tenants in common, there's no rights of survivorship. So what does rights of survivorship mean? It refers to what happens to the property if one of the owners passes away. So here's how no rights of survivorship looks. So we have this member or this owner passes away. His share goes to his estate, which would be his children, and that may take either a probate to transfer that share to them. So yeah, tenants in common, you got to be careful with no rights of survivorship. What happens to the ownership when someone passes away? It's just part of their estate. If they have a last will and testament, that controls where the assets of the estate go, but it could trigger a probate in order to make that transfer. Okay, the other major option or the other way to own property with multiple owners is with joint tenants with rights of survivorship. So you have to specifically say this. On the deed, it has to specifically say with rights of survivorship in order to be treated that way. If it doesn't clearly say with rights of survivorship, then the presumption is tenants in common. Okay, there's how it's abbreviated. That's how, I think that's common abbreviation, joint tenants with rights of survivorship. It's just so wordy, so many words, but very important distinction there to determine what happens to the property if one of the owners passes away. Now, if husband and wife own a property together and the deed says Mr. Estate, Mrs. Estate, husband and wife, then there is a presumption of rights of survivorship, but sometimes you have to fight with the title companies to get them to understand that. The law is not super clear on that. It seems clear to me, but some title companies will take a position that they want to see a probate if it just lists husband and wife and doesn't specifically say with rights of survivorship. Okay, so with rights of survivorship, so if one owner passes away, now there's three owners of the property. That's what rights of survivorship means. So it means that um, the other surviving members get the rights of ownership. So now there's three owners because he passed away. So we saw earlier with the tenants in common, when one owner passed away, their share went to their estate. With rights of survivorship, it goes to the other owners of the property. Now, for married couples, there's another option. It's called community property with rights of survivorship. Basically the same thing, but a little bit different tax treatment. So I'm not going to get into the community property stuff today, but just understand this rights of survivorship is the major thing when you're owning property with multiple owners. Okay, so what if you take title in your trust? So the other topic of today's video is how can you take title to a property and keep your name off the public record? How can you maintain some privacy and really asset protection? Now, I always tell people there's no one thing to asset protection. It's all about layers, and by keeping your information anonymous is a major layer that makes it harder for people to figure out who owns the property if there is some sort of liability created there. So when you take title in the name of a trust, this is what we do for planning purposes, and this is how we recommend that you take title to your primary residence. Now, even if you had a stealthy name of your trust, that didn't include your name on it, in Arizona, the law requires the deed to disclose who the beneficiary of a trust is. So this example, Mr. Estate, he had a stealthy name for his trust, but on his deed, it's still got to say that Mr. Estate is the beneficiary of that trust. So going back to this example, so beneficiary, this hand is what I use to indicate the beneficiary. So he's the current beneficiary of the trust, meaning that he has all the rights to the trust, and then the trust designates a future beneficiary. Okay, so taking title in the name of the trust, you still have to disclose who the trustee is. Now, what if you take ownership of a property in the name of an LLC? Then what gets disclosed? So the law requires that you have to have the name and address of the members of the LLC. So they have to be published on the Corporation Commission website. So if you take title to a property in the name of an LLC and you're the owner of an LLC, people are going to be able to determine that easily just by looking up on the Corporation Commission and with a simple search. So what do you do? How do you keep your privacy? So the privacy trust, this is the way to do that. So this is a special type of trust. You can give it a generic name, so you don't want to include your name as part of the title of this trust. This example here is just the generic name trust. Not very creative here for Mr. Estate. Generic name trust. So he's the trustor of it, the trust creator, shown by that briefcase. He's the trustee, the one that manages the trust. But the beneficiary is not Mr. Estate himself. So the person or the beneficiary of this privacy trust, it's actually going to be his regular revocable trust. So that's the beneficiary of this privacy trust. Now, in order to remain anonymous, he needs to utilize our address service. He needs someone else's address on the record. So Mott Legal, you can name us as your statutory agent, and you can use our address as well. So that way, if someone looks on the Corporation Commission, they'll see the name of they'll find the name of your LLC as the owner of the property. And then when they look to see who the owner of the LLC is, they'll see that it's owned by a trust with a generic name. And then the contact information for the trust is going to be our address, the Mott legal address. So this is how you maintain privacy. So the ownership on the public record is a generic name trust, the ownership is it's an LLC. Now the owner of the LLC is this generic name trust. So if people try to figure out who the owner of the LLC is, they'll find this trust, and then they'll find it lists the address of our law firm. So they're not going to see your name or your specific details on the public record. So pretty cool stuff, something I've been pretty excited about. And let me show you how it looks on the Corporation Commission. So here's one I just did this morning. So let's search, and here's what it looks like. So you see the entity name here, just a generic name here, and agent name is Mott Legal. And then let's click on this, see what else we can find about this. Now, so entity name RPRK LLC, active and good standing, created today. And the address, or the statutory agent, it shows Mott Legal is the statutory agent. The manager is the RPRK Trust, and attention Mott Legal. So we get all the mail for this trust. If anything was sent, it would come to our address there at Mott Legal. And the member is a trust that also lists the Mott Legal address as well. So this is how you keep all of your name off the public record. Keep everything confidential. So pretty cool. A nice way to do it. Makes it easy. You don't have to deal with anything else. Let's see here. Let me add my little, there you go. So I'll add our contact information there at the bottom. If this is something you're interested in setting up an LLC for yourself and holding assets privately, you can do that with a privacy trust. Now, if you already have some things in your name and you want to switch over, what I would recommend is probably creating 2 privacy trusts, where you create one and transfer your existing stuff into that, and then create a new name going forward where you start accumulating assets under that new name that isn't connected to your old entity, where people can figure out who the owner is. Now, like I said, some people watching might say, well, that's extreme. Seems like a lot of work to remain anonymous. Why would you go through that hassle? Why would you do that? Again, it's all about just layers of asset protection. If someone gets hurt on a property, then they're going to sue the owner. And Attorney 101, they're looking for the money. They're looking for how they get paid. So if they can easily find out that the owner of this property owns several other properties, then the likelihood that they can get paid if they're successful and get a judgment is more likely if it's someone that owns a lot of property. Now, if you don't know who the owner is, and a public record search doesn't reveal that they own other assets or other things, then you would ultimately have to file a lawsuit against that entity to disclose who the owner is, and then see, then after you pursue litigation, you can see if you can even collect on that debt, collect on that judgment. So just a way to add another layer of protection to your plan. If that's something of interest to you, you can come see us and we can add that for you. If you want to get just a regular estate plan set up, make sure your family avoids probate and doesn't have any surprises, we can help with that as well too. Thanks everyone for watching. We'll see you next week.